What if I told you that the moment your boss asks to search your bag, you actually have less protection than you'd have during a random police stop on the street? Sit with that for a second. Because most people assume the Fourth Amendment, the same one that stops police from searching your car without a warrant, follows you into your workplace. It doesn't. And that single misunderstanding has cost people their dignity, their jobs, and in some cases, their legal claims, because they didn't know where the real protections actually live. Picture this. You're clocking out at a retail store after a 9-hour shift. Your feet hurt, you just want to go home. And then a manager stops you at the door and says, "We need to check your bag before you leave." Your stomach drops. Not because you did anything wrong, but because being searched feels like being accused. You start running through your head. Do I have to say yes? Can I just walk away? Is this even legal? And here's the part that surprises almost everyone watching this video right now. The answer depends almost entirely on one detail that has nothing to do with what's in your bag and everything to do with who signs your paycheck. Let's start with the biggest misconception out there, because it's the one that trips up more people than anything else in workplace law. The Fourth Amendment protects you from unreasonable searches and seizures. That part is true, but that protection was written to restrain the government, not your employer. It's what lawyers call the state action doctrine. Constitutional rights, for the most part, apply to interactions between citizens and the government, police, public schools, government agencies. When you're dealing with a private company, a private employer, a private store manager, the Constitution generally isn't in the room with you. Now, before you feel like the rug just got pulled out from under you, stay with me, because this is where it gets more interesting, not less. Because there's a very real exception to this, and it changes everything. If you work for the government, a public school, a city agency, a state university, a federal office, the calculation shifts. The Supreme Court actually addressed this directly in a case called O'Connor versus Ortega back in 1987. That case involved a doctor at a state hospital whose office was searched by his public employer. The court said that public employees can have a reasonable expectation of privacy in the workplace, and that searches by government employers do have to meet a standard of reasonableness. Not the same warrant requirement police need on the street, but a real standard nonetheless. The search has to be justified at its inception and reasonable in its scope. So if you're a public sector worker, you actually do carry a thread of constitutional protection into that break room, that locker, that desk drawer. If you work for a private company, that thread isn't there in the same way.
So, does that mean private employers can search you anytime, anywhere, for any reason? Not exactly. And this is where most videos on this topic completely drop the ball, because they either tell you that you have no rights at all or that you have all the same rights as a criminal suspect. Neither one is true. The reality lives in the middle, and it's shaped by three things: your employment agreement, your state's laws, and whether you're part of a union. Let's talk about the employment agreement first, because this is the part almost nobody reads. When you're hired, especially at retail companies, warehouses, and logistics centers, there's often language buried in the employee handbook or the onboarding paperwork that says something like, "Company reserves the right to inspect bags, lockers, and personal belongings on company property." By signing that, or even by continuing to work after being notified of that policy, you're generally giving what's called implied or express consent. That consent is a big deal legally, because most search-related disputes in the private workplace hinge on whether you agreed to the possibility of being searched, not on whether the government violated your rights. Now, here's a fact that surprises a lot of people. Some of the biggest retail chains in the country have actually faced lawsuits over their bag check policies, not because searching bags is inherently illegal, but because of how the searches were conducted. There have been class action cases across the country, particularly in places like California, arguing that employees should be paid for the time they spend waiting to be searched, especially if that wait happens off the clock after their shift technically ended. That's not a Fourth Amendment issue at all. That's a wage and hour issue under labor law, and it's a completely different legal battlefield than most people expect when they think about their rights during a bag check. So let's pause here and ask the question building underneath all of this. If the Constitution mostly stays out of it and your handbook says they can search you, does that mean you just have to comply no matter what? Even that answer isn't as simple as yes. Because there's a difference between a company having a policy that allows searches and a company having the legal right to physically force a search on you. In almost every state, an employer cannot physically restrain you, block you from leaving the building against your will, or forcibly take your bag from your hands. If they do, that can cross into false imprisonment or even assault and battery under civil law, and in some circumstances, criminal law too. What an employer generally can do if you refuse a search that's outlined in company policy is treat that refusal as a violation of company rules, which can lead to disciplinary action or, in an at-will employment state, termination. And that's the trade-off most people don't realize they're making. You do have the right to say no, but your employer may also have the right to fire you for saying no, depending on your state and your employment status. This is the point in the story where a lot of people say, wait, so I could get fired just for refusing to let them look in my purse? And the uncomfortable truth is, in most states, yes, that's possible, because the majority of the country follows at-will employment, meaning you can be let go for almost any reason that isn't specifically prohibited, like discrimination based on a protected class. Refusing a routine, previously disclosed bag check generally isn't considered a protected activity.
But, and this is a big but, there are situations where the search itself becomes illegal, even in a private workplace. If a bag check is used as a tool for discrimination, say only certain employees based on race, sex, national origin, or another protected category are consistently singled out for searches while others are waved through, that can trigger liability under Title VII of the Civil Rights Act or the equivalent state anti-discrimination laws. So the search policy itself might be legal, but the way it's applied unevenly can become the actual violation. That's a distinction that trips up business owners and employees alike. Now, let's bring in a completely different angle, one that almost nobody talks about, and it involves unions. If you're part of a unionized workforce, you may have something called Weingarten rights. This comes from a 1975 Supreme Court case, NLRB versus J. Weingarten Incorporated. That case established that in certain investigatory interviews, meetings where an employee reasonably believes discipline could result, a unionized employee has the right to request a union representative be present. Now, this doesn't automatically apply to every single bag check at the end of a shift, but if that bag check turns into an accusatory interview, if you're being pulled aside and questioned about a specific incident, like a missing item, that additional right can potentially come into play. It's one more layer that shows how much your specific situation, your specific workplace, and your specific job classification actually change your rights, far more than people expect walking into this topic. Let's shift for a moment into a scenario that raises the stakes even further, because bags aren't the only thing on the table. What about your car in the parking lot? What about your phone? These come up constantly in questions people ask, and the answers genuinely differ. Your vehicle, even when parked on company property, is generally treated with more protection than a bag you're voluntarily carrying into a break room, because courts have historically recognized a stronger expectation of privacy in a personal vehicle. Several state courts have ruled against employers who searched employee vehicles without a specific and narrowly tailored policy addressing it, especially when that policy wasn't clearly communicated in advance. Your phone raises its own separate set of concerns, layering in device privacy laws, and in some states, specific statutes that restrict employers from demanding access to personal social media accounts or personal devices, unless it's connected to a legitimate, work-related investigation, and even then, often within narrow limits. So here's where the picture starts coming together.
Whether your bag can be searched, whether you can refuse, and what happens if you do depends on a web of interconnected factors. Are you a public or private employee? Does your handbook mention search policies? Is your state an at-will employment state? Are you in a union? And is the search being applied evenly, or is it targeting you specifically? That's not a simple yes or no answer. And honestly, that complexity is exactly why so many people feel powerless in that moment at the door, bag in hand, manager waiting. But knowledge changes that moment entirely, because now, if you're ever standing there, you know you can calmly ask whether the search is part of a written company policy. You know you can ask whether you're free to leave without answering questions beyond a basic bag check. You know that raising your voice or trying to walk past someone physically is far more likely to create legal trouble for you than for them. So staying calm and clearly stating that you don't consent, if that's your choice, while not physically resisting, is almost always the smarter path. Compliance with a request doesn't erase your right to later dispute how it was handled, and disputing it later, calmly through HR, through a labor board complaint, or through an attorney, is a far more effective tool than resistance in the moment. And here's the insight that ties this entire topic together, the one most people never hear until it's too late. Your rights in the workplace aren't really about a single dramatic constitutional showdown like you see in police procedural dramas. They're about paperwork you signed on day one, policies buried in employee handbooks, state statutes that vary depending on where you live, and protections that only activate under very specific circumstances. The manager asking to look in your bag isn't Fourth Amendment territory most of the time. It's contract law, labor law, and state privacy law all working together, quietly in the background of a moment that feels intensely personal.
So the next time you're standing at that exit, bag in hand, you're not powerless and you're not defenseless. You just have to know which legal door you're actually standing in front of, because it's rarely the one people assume. If this raised more questions than it answered, you're going to want to watch the video I made on exactly what happens when police, not your employer, ask to search your phone during a traffic stop, because the rules flip completely, and most people get that one wrong too.